Okay, I'm back and we're ready to start this morning's webinar. Welcome, everybody. I guess I'm getting old because I always used to pride myself on embracing new technology and try to be ahead of everybody else. But in recent years, I just get more and more nervous. This morning, I opened up my laptop to begin this presentation, the setup and everything, and it told me I needed a bunch of updates. And then things started to happen. I couldn't log in. We needed to change passwords, and oh my gosh. And so we were down here to the wire, and even still, there were messages that led me to doubt that things weren't working, but it looks like everything's working. So hopefully, fingers crossed, we'll make it through this without any hiccups. Welcome to this morning's webinar, where we're going to be discussing laws that protect information. Interesting topics here today. A couple preliminaries before we dive into it, though. As you can imagine, given the screen, this is a PowerPoint presentation with me talking in the background. The PowerPoint is available on the Office of Open Records website, and the URL is on the screen right now. You can go on the website, tab over to the training tab, and go down through. And you will find all of the PowerPoints that we use for our trainings, and you're welcome to download them as you see fit. It's possible that you have a colleague who couldn't join us this morning, so they may benefit from it, perhaps just for your own future reference, or maybe you're interested in conducting some sort of localized training. Feel free to download any of those PowerPoints and use them as they would benefit you. Also, this session is being recorded, and again, you're welcome to access those recordings. I believe the protocol is that you contact our office, and they will send you a link that will allow them to share it with you. It's also typical that they end up being uploaded to our YouTube channel in a couple days once they're cleaned up, and you can access them from that point. You can ask questions today. The way you do that is typing in the chat feature. I will do my best to answer them live. However, two conditions. First is that we are talking, okay, audio feedback. If anyone else is getting audio feedback, please let me know. I might have to turn off a microphone. Doesn't look like it. If you're having a problem, oh, someone is. Okay, I'm not sure what's going on, guys. All right, sounds like some are and some are not. Try logging out and logging back in. You know, it's an age-old solution to just about everything, but it might work. Okay, so yeah, back to what I was saying. As far as the questions go, first offhand, we are talking about laws that protect information, so let's try and stay on topic. But more importantly, try to keep your questions as brief and succinct as possible. What happens is every so often someone will type in several paragraphs, and it's just awkward for me to sit here and read through it while everyone is waiting patiently. If it appears that you've got something unusually complex or unique to your situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll come back to it and try to address it for the good of everyone, or we'll take the conversation offline. The contact information for the office is on the screen now. Typically what happens when you send us an email or call, our admin staff is the first line of defense, if you will, and they are fairly well-versed, well, very well-versed in the Right to Know law and the Sunshine Act, and can typically get you steered in the right direction. If you happen to stump them, then we escalate your question up to senior staff, and they're pretty good about getting back to you right away. And again, we try and get you steered in the right direction. Look, we can't write requests for you. We can't respond to requests for you. We can't talk about any active appeals that might be before the office, and we can't provide legal advice. So don't ask us for stuff like that. But we will try and get you steered in the right direction because we figured, well, you've got a problem and it's serious. You're reaching out to us. So we pride ourselves on how we're able to help the public or agency open records officers who might need some assistance. Okay, so all that being said, let's go ahead and jump into the presentation. And I want to talk about just why this topic is important. And the first is that if you're familiar at all with the right to know law and you sat through that basics training that we do, you'll be familiar with the fact that the right to know law is not a confidentiality law. Within the right to know law, there are those 30 exemptions that we talk about. Those exemptions are definitions of types of records that the agency may withhold from release to the public. That word may is very important in this context because an agency can release a record that falls within the definition of one of those exemptions if it feels compelled to. However, this topic is important because there are other laws that remove that discretion and supersede the right to know law. So even though an agency may feel, well, there's no harm in releasing this, let's just go ahead and do it, it's imperative that they be aware of any other laws that say, hey, wait a minute, no, you're not allowed to release these records. And today we're going to talk about the ones that our office most commonly comes up against. And this is all summarized in Section 306 of the law, where, just paraphrasing here real quick, nothing in this act shall supersede or modify the public or non-public nature of a record as established by federal law, state law, regulation, or judicial order or decree. Okay, so that means any other law that says these records are confidential, or if a judge has said these records are confidential, that supersedes the right to know law. The other thing that makes this topic critical is the whole burden of proof aspect of the right to know law. Again, sitting through basics, if you've done that, you would be familiar with the fact that the agency bears the burden of proof as to why, why a record should not be released into the public domain. Well, typically, the agency would reference one of those 30 exemptions in the right to know law. But what if the exemption doesn't apply, but yet you're still concerned about releasing these records? Well, it's very well possible that there would be a confidentiality clause in one of these other laws that would make the record confidential. And you would not release it based on referencing that confidentiality clause in the other law, in these laws that we're going to talk about here this morning. So you see how that works. And sometimes you can piggyback. You can say, not only is this record confidential because this particular exemption within the right to know law applies, but we also rely on the language contained in this other law. And, so you're using more ammunition, more support for withholding that record based on what usually is more comprehensive, tighter language in these other laws that say you cannot, the agency cannot release these records because this law deems them as confidential. So you see how this all fits together. So, if you're here from the agency side, it's important to be aware of these other laws because they remove any discretion that you have, but they also provide additional legal basis. They allow you to meet your legal burden of proof as to why these records should not be released. And then you in turn reference that in the denial letter that you put forth, denying the right to know request. And if you're here from the public side, it's helpful to know that there are other laws in play here that not only give the agency the option, but in most cases remove any discretion that the agency has. It's not that they are using this law so that they don't have to release the record. It's this law probably says you may not release the record. And oftentimes there are sanctions of some sort if they would release the record and thus violate those confidentiality provisions. Okay, so yeah, that's a mouthful, but I just want to emphasize why this is an important topic, and it's necessary for agencies in particular to be aware of the presence of these. Now, like I said, we're just going to talk about the the top 10, if you will, or I think it's 14. But these are the ones that historically the Office of Open Records has come up against most frequently. So let's move on and talk about the first one, which is probably the most common, the Criminal History Records Information Act of 1980, or what we commonly refer to as CRIA. Okay, now CRIA applies to any person or agency that collects criminal history information. So we're talking about police departments, prisons, district attorneys, sheriff offices, the courts, and so forth. It protects criminal history, investigative and intelligence information. Now, a lot of this is very similar to the exemption within the Right to Know Law, 708B16, that covers criminal investigatory information. However, if you look at B16, there's no reference to intelligence information. So, quick example here. Let's say that our police department monitors suspected gang activity within the jurisdiction, and we keep a file on it. Someone submits a right to know request asking to see that file. Under the right to know law, technically we can't withhold intelligence information. But if I go to CRIA, since it specifically mentions criminal intelligence information, that's how I would build my legal case for withholding that and in turn denying the right to know request. Now, under CRIA, this information, these records, can only be shared with other applicable law enforcement agencies. And this raises another important point. Again, if you sat through these, you know what I'm about to say here about the definition sections of laws. Whenever you're trying to understand the law, sometimes that can be, harder said than done, because it's oftentimes written in legalese. You will oftentimes run up against vagaries. Sometimes it appears that sections conflict with each other. Oftentimes, you can shed light upon the issue by reading the definition section of that law. And CRIA is no different. And I mention it here because CRIA defines law enforcement agencies. There are other laws that do the same. Uh-oh, what just happened? Okay, I think something may have crashed. I'm not sure. I'm going to go back to sharing and see what's up. Okay, it looks like I may have gotten kicked out of the meeting. Okay, same deal. If you can hear my voice, type in, just no visual. Okay. Let me see if I can figure out what's going on here with the slides. Yeah. Hold on here. I'm just, yeah, my PowerPoint crashed. That's really strange. Told you there were some issues here today. Let me bring PowerPoint back up. Share this, Teams. Share. Okay, looks like we're headed in the right direction here. Let me, okay, I think we're back up and running. Um, okay, so yeah, thank you. Sorry about that, folks. Okay, so CREA defines law enforcement agencies in a very narrow context, like we said, police departments, prisons, and so forth. There are other laws that have a much broader definition of law enforcement. For instance, Act 22, that deals with dash cams, body cams, security cameras, defines law enforcement agency as any agency that employs a law enforcement officer. Well, believe it or not, school district could be a law enforcement agency, charter school, Amtrak, and the like. So it's important to be aware of these definitions because it will have an impact on how this information can be disseminated. A very good resource is a handbook put out by the Pennsylvania Attorney General's office. Also, just that office per se, if you have questions about CREA, give them a call. They have subject matter experts who will get you headed in the right direction. I've had conversations with them myself and come away very pleased with their insight and knowledge of this law. Okay, moving on. We want to talk about a related law, Act 30 of 2016. This applies to public safety answering points, more commonly known for the most part as your 911 centers, your county 911 centers. Act 30 protects individual identifying information, callers, witnesses, and victims. So anything related to the name, telephone number, or home address of one of these parties, the 911 center simply cannot give out. Now, it protects the location of the address. Well, it doesn't protect the location unless it would compromise any of the above. So how do they get around this? They can give out block numbers, cross streets, and mile markers. Now you're thinking, okay, well, I've seen on TV, the exact address, they've interviewed witnesses, they've interviewed victims and the like. Well, that's just the reporting, working through other sources other than the 911 centers. The 911 centers for, public dissemination, maybe to avoid traffic jams or whatever, they can give out block numbers, cross streets, and mile markers. So for instance, this morning, I'm here in 333 Market Street in downtown Harrisburg. However, if there were an incident in the building, the information that would go out would be the 300 block of Market Street, or at the corner of 4th and Market, or if we were out on the interstate, they would give out the mile marker, okay? But they cannot give out the actual street address because of privacy concerns, more related to residences than commercial structures. All right, here's a common one. It's always fun to deal with: attorney-client privilege and work product. And this applies to solicitors and their client agencies. Now, attorney-client privilege protects any sensitive communication between lawyers and their clients, legal advice, legal strategy, work product, and the like. So in our context, dealing with the right to know law, we're talking about solicitors and their client agencies. Any communication, whether it be email, reports, notes, and that sort of thing, is typically protected by attorney-client privilege. In Pennsylvania, we have the rules of evidence. Attorney-client privilege is mentioned there. It's also specifically referenced in the right to know law under Section 305. Now, occasionally, and this just came up recently, where this happened and we got some questions about it, there was a meeting between a solicitor and a counsel. One of the council members then turned around and repeated what was said in this executive session, is what it was. At that point, when that happens, privilege is lost, okay? So if someone were to, let's say it involved the content of a record that was exchanged between counsel and their solicitor, because that privilege was broken when the one counsel person went and shared it, no longer could attorney-client privilege apply in this case. Now, the question really, the context of the question was, is there anything we can do to this counsel person? For purposes of right to know, the answer to that is no, but there are other options available to the counsel. But you see what happened there. If one person shares that record, then it's no longer considered privileged. Now the question always comes up, well, what about legal invoices? Because, you know, I'm going to file a right to know request because I want to know how much my township is paying for legal services, because it may be on an hourly rate, maybe per diem, it may not be a set annual fee or a salary because it's, you know, done by contract as opposed to in-house counsel. So they want to see the invoices. And then the question comes up, are we allowed to share these invoices? Well, you have to look at the invoices on an individual basis and answer the question, do they go into such detail that we can discern legal strategy from the detail of the invoice? If your solicitor is just saying, you know, for the last month, I worked X number of billable hours, so pay me this number, pay me this amount, that doesn't discern legal strategy in it. It doesn't reveal legal strategy. However, if they're saying, you know, I spent 3 hours interviewing potential witnesses for deposition, or I spent X number of hours researching case law on this particular strategy related to this docketed court case that we're preparing for. If you can get an idea of the legal strategy that your solicitor is taking on a particular case based on the detail that they go into on the invoice, then it's possible that you could claim attorney-client privilege on the invoice. It just depends. My advice is, if you are an agency open records officer and you're wrestling with this, go to your solicitor and ask them, you know, what's your opinion on your invoice? Should we withhold it based on attorney-client privilege? If you end up denying it, if you end up denying the right to know request, that individual can always file an appeal, and we'll sort it out here at the Office of Open Records. It happens, you know, periodically. That's why we bring this up. We'll take a look at it, and if we believe attorney-client privilege does apply, then we'll uphold the denial. Okay, so that's, you know, attorney-client privilege and how it relates to withholding various public records. Jumping around a little bit now, here's one that also, this still comes up fairly, you know, regularly with the Office of Open Records and Appeals that we deal with, and that is the Uniform Construction Code, or, you know, again, more commonly known as UCC. The Uniform Construction Code is Pennsylvania's statewide building codes, and it applies to any agency that would possess building permit applications, plans, and associated records. So typically, you would see these at the local government level where they're approving building permits, but you might find them, for instance, at the state level with, in particularly the Pennsylvania Department of Labor and Industry. But it protects all applications, those building permit applications, building plans, specifications, inspection reports, similar documents for buildings constructed after 2004. Okay, why 2004? Because that's when Pennsylvania adopted the UCC. Prior to 2004, it was a patchwork of various building codes throughout the Commonwealth, depending on the jurisdiction. I'm old enough to remember when this happened, and you had, at that point, you had the UCC, you had the Life Safety Code, you had the BOCA Code, and many jurisdictions had their own local building codes. So if you were a developer or a contractor, it was hard, it was confusing going from one municipality to another, knowing what you had to do if you were putting up a new building or doing some major renovations or whatever, what the requirements were. So Pennsylvania adopted this uniform code. Now, if you're looking at a building constructed before 2004, you would have to go back and find out what was the building code in force for this jurisdiction at that time, if you can, if you're successful in doing that, and determine what were the confidentiality provisions prior to 2004, and then apply that to the right to know request. But for UCC, 2004 on, and there is a confidentiality provision in there that determines what records can and cannot be released in response to a request for those records. Now, building permits themselves are considered public records. It's all of the supporting paperwork that goes into the issuance, the decision that resulted in the issuance of that building permit, that typically are considered confidential. Now, there is a provision within the confidentiality provision that, look, if I'm the building owner, I can designate a release on a need-to-know basis of this information. So if I've hired a contractor to come in and renovate my structure, and he needs, or that contractor needs, the building plans so that they know what's behind this wall, or they want to get more information on the HVAC system or whatever, so they need the specifications. I can, as the building owner, release those records and authorize the local municipality to give them to the contractor. And anyone who has a bona fide need to know, I can say it's okay to go ahead and release these records. The other thing that you need to be aware of is that it's a fairly common misunderstanding, and here's why, that the UCC only applies to commercial structures. Under a decision issued by the Office of Open Records, Ness versus York Township, going back to 2012, based on what the UCC doesn't say, as opposed to what it does say, we concluded that the privacy language in the UCC applies to residential as well as commercial structures. And I went back and read this decision, and it's interesting how the late Charles Brown arrived at this conclusion, but it really makes a lot of sense. Reading through the UCC and the privacy provisions, for the most part, it will specifically mention commercial structures, okay? But then you get into this portion of the UCC where it talks about building plans and what can and cannot be released, and suddenly the term commercial disappears, and it starts referring to basically structures, not commercial, not residential, just structures. So using that lack of language, if you will, our office concluded that the privacy language applies to residential as well as commercial. And from a pragmatic perspective, it answers the question, well, why would you release building plans for a private residence? You know, obviously, you would not do that. So this gives you that legal basis for withholding any requests. And it's odd, but we still see these right to know requests where so-and-so wants to see the floor plan for somebody else's house. Well, you know, it's none of your business. So the UCC gives you that legal basis for withholding those records related to that particular right to know request. Now, any citations, you know, let's say someone violates a building code and it ends up in court, well, then it's a court record and it's accessible through the court system. And then we get questions about zoning boards, you know, well, this is not, the UCC does not apply to building zoning. Rather, that's another law called the Municipalities Planning Code. And that has its own provisions on what can and cannot be released. Okay, I'm going to get a quick sip of coffee here. And then we'll talk about all these health-related laws that we need to be aware of. Okay, the first one I want to talk about, and it's probably the most commonly known and referred to, is the Health Insurance Portability and Accountability Act of '96, Hippa. Okay, again, I'm old enough to have been around when Hippa was made law and how it had an impact on businesses and the employer-employee relationship. Now, Hippa applies for the most part to healthcare providers, not to employers, but yet we still run across incidences where an employee can approve the release of health information to an employer, but then the employer must keep it secure. Okay, and there's another law where I'm going to give an example where this applies better. But the reason that I put it in here is, number one, just to emphasize the fact that health-related information for anybody is considered confidential and should not be released. And you're going to find provisions within the right to know law that support this. But again, HIPAA removes that discretion. But there's a thing, we call it individually identifiable health information. Okay, so if there's any way that information can be released, whether it be at an individual level or an aggregate level, that can nevertheless be sliced and diced down to the point that would allow you to identify a particular individual, you do not release it, okay? And HIPAA would have that provision within it. And there are sanctions so that if you would release individual health information, the person could file suit, and the agency or the guilty party, if you will, would be subject to some form of sanction. But we still run across instances where, for instance, we used to have the what was called the county home. All right, well, depending on the county that you live in, there may be a senior center, and given the nexus, whether it be direct or through contract, one could successfully argue that the legal jurisdiction is in possession of health information for individuals, whether it be employees or residents of one of these senior centers. HIPAA allows that jurisdiction to protect that information legally and not give it out through any form of right to know mechanism. Okay, another law closely related is the Family Medical Leave Act, FMLA. Now, this does apply to employers for the most part, and should be of particular import if you're a human resources leave administrator or the supervisor of employees. So the Family Medical Leave Act, in addition to all of the entitlements within it, I use the term entitlements, without malice in any way, but it protects leave or accommodation related records that would otherwise disclose the presence of a serious health condition. Okay. In a previous career, I was the human resource director for a large state agency. And again, I remember when FMLA came out, and this term serious health condition drove us nuts because it took years to figure out exactly what was a serious health condition. And it's still evolving. I mean, I don't want to go there and get involved in a political debate, but it seems to be a moving target. And we wrestled with it for quite a while as to what this law meant. But essentially, for our purposes here, because FMLA entitles public employees in particular to different types of leave, you want to be very careful about right to know requests that are aimed at an employee's leave usage, because it's possible, without even realizing it, you could divulge the presence of a serious health condition. And I'll just give you a quick example. We've got a public employee who has a nosy neighbor. This employee was at home during otherwise normal work hours and was mowing the grass. Okay, so nosy neighbor files a right to know request with the employer, the public employer, for this employee's leave records, because they want to know, did this employee put in for vacation this day when they were at home mowing their grass? Okay, and it happens, unfortunately. So the agency says, well, yeah, there's nothing wrong going on here. This employee was on vacation that particular day, and they released the leave records. All right, so now let me go into a hypothetical. Let's say that this same employee took 3 consecutive days off sick. Okay, now if you're familiar with this topic at all, under FMLA, the HR leave administrator should, and I put should in quotes, should have sent a survey form to the employee. Was this absence related to a serious health condition? Because if that's the case, then the employee, number one, they're entitled to FMLA leave, but also the sick leave that they took gets credited to their FMLA leave balance. Right? Now I realize I'm getting into the weeds here, and a lot of you, you're probably fogging over what's he talking about. But the point being that by giving out a leave record that shows 3 consecutive sick days, you could potentially be revealing the fact that this employee suffers from a serious health condition, and you have thus violated the Family Medical Leave Act and could be subject to sanctions. So you see how that is problematic. My advice is take a very good look at these and maybe establish a policy of not giving out any leave records. You're just going to have to live with the fact that this employee is going to claim some sort of cover up, or not the employee, the requester is going to claim some sort of cover up or whatever. But, weighing the various factors here, my recommendation, and again, not legal advice, but my personal recommendation is just don't give out leave information for fear of potential violations to one of these laws. Now, an employee can voluntarily give out information, typically to their supervisor, which the point of this being that if I, and let me just put an example out here that'll make things easier. You have an employee who is an epileptic. All right, so they notify their supervisor, hey, I suffer from epilepsy. I've had seizures from time to time. If by chance, when I'm here at work and something happens, you should be aware of that. Okay, so the supervisor is now aware that this employee has a serious health condition. They suffer from epilepsy. One day, the employee does have a seizure. Okay, so 911 is dialed. The first responders show up. The supervisor is then authorized to notify the first responders. This employee let me know that they've suffered from epileptic seizures in the past. Just thought you should know. All right, and then that gives the first responders, a direction to go to in how they would then treat the employee and what's happening there. Okay, but it's only on a need-to-know basis that this otherwise confidential health information is released. Okay, and I already talked about the whole record of absence issue. Okay, another health-related law that you should be aware of is ADA, the Americans with Disabilities Act. On leave. What about agencies routinely responding to media questions if someone is suspended with or without pay for some reason? Okay, well, that's a different reason. And I think, well, first of all, ADA would not apply here because the reason for the absence is clearly disciplinary in its nature. All right, so we're not crossing that gray area. You would not be releasing a leave record per se that could potentially show 3 consecutive sick days. You're simply stating to the media that this employee is on suspension, whether paid or unpaid. Okay, you're not getting anywhere close to the world of FMLA because there's no mention of sick leave or a serious health condition. And you're probably not releasing the leave record. You're just simply saying this employee was suspended because of a disciplinary related matter. Or it could be, like a shooting, a police officer shooting, where the employee is being suspended with pay pending investigation. Okay, it's fairly common occurrence, and it's simply to determine whether or not discipline is warranted, not whether it's disciplinary in nature. But there's no mention whatsoever of any other sort of leave that comes into the context of the question and the information that is released. So I think you'd be okay there, Stephen. Well, I'm sure you'd be okay. Okay, ADA. Yeah, here's one that I want to talk about. ADA also applies to most employers, okay, because you're talking about disabilities. And that information, any ADA-related medical record or any medical record per se, must be stored separately from other personnel-related records, okay? This is just for the good of the order here. Again, I remember when this happened, okay? I was the HR director, and up to that point, if I wanted to go over and look at somebody's personnel file, I could open it up and there was health-related information. Well, ADA came around and we had to pull all that information, create a separate series of files for all these employees, and only our benefits staff had access to that information. I could no longer get access to health-related information for employees. It was all kept separate and under separate lock and key. But again, what if an employee voluntarily discloses information, but through a non-medical related inquiry? And I'll give you an example. We've got a borough, okay? And their offices are in a multi-story building. And like many government agencies, they've appointed a fire marshal, okay, as an employee, so that if there is an emergency or a fire drill, whatever, you're in charge. You make sure everything goes smoothly and as it's supposed to. Well, this fire marshal, being the good employee that they are, they send out a survey. And it's essentially, if we need to evacuate the building due to a fire or a fire drill, do you need any help getting out of the building? And that's the essence of the survey. Well, one employee responds back, yes. 2 years ago, I had a hip replacement, and I have trouble walking down steps. Okay, and you know, if there's a fire or a fire drill, typically they tell you don't take the elevators, or if the elevators are up to date, up to code, they all go down to the first floor and you're locked out. So the fire marshal decides, okay, I'm going to let the assistant fire marshal for that particular floor know about this employee's concerns, so that if there is an emergency, we're going to take them to the stairwell and stage them in place at the top of the stairwell. And then I'll notify the first responders that they need to evacuate this person. All right, so you see how that all works. Through a non-medical inquiry, the survey, the employee has divulged the fact that they have a condition that requires assistance in the event of an evacuation. All right. Technically, that information, health-related information, would be kept confidential. But here, again, on a need-to-know basis, the information is released to parties that need to know. So then the fire department shows up, the fire marshal immediately notifies them, we have an employee with mobility issues. He's staged, or she is staged on the third floor landing of the stairwell. You're going to have to go up and get him. And then the fire department responds accordingly. Okay, let's move on. And we're going to change tacks here after a sip of coffee. And this is one, you know, this should probably move up on the list. I think we get more FERPA-related appeals than the health-related ones these days. So yeah, I need to take a look at that. But anyway, FERPA is the Family Educational Rights and Privacy Act. This applies to public and private schools, and it could be primary, secondary, post-secondary. Private schools, charter schools as well. But it protects individual educational records for students, okay? Report cards, transcripts, any record of discipline, for the most part, it's all kept private, and FERPA says you will not give this information out, these individual educational records. Okay, well then you're thinking, what about when you know, the local TV station reports on you know, someone being selected for the all-county team, sports team, or you know, so-and-so got a full-ride scholarship to Yale, and we're going to do a piece on them. Well, this is typically because the school district has released this information under a provision of FERPA that allows for directory information to be made public. Okay, so again, you go into the definitions, what is directory information, and it tells you, okay, and it's where it's essentially human interest, where we want to recognize the accomplishments of one of our students or a group of our students, so they're allowed to do that. Back when we had newspapers, you know, you would get the quarterly honor rolls for the local high school, you know, and so forth. Now, what about aggregated data? This can be released to the public. And this oftentimes, you know, there's all these reports that have to be filed with the Pennsylvania Department of Education, with the Federal Department of Education, and so forth and so on. You know, No Child Left Behind Act, and so forth.
So people file a right to know request for copies of these reports because they represent aggregated data on how well our schools or our school districts are doing. And, they get ranks and information is released and so forth. Now, this has come up we're probably going back 2 years ago, but yeah, even longer than that, because I think I was still working here at the Office of Open Records as an employee. So yeah, it's at least 3 years now, I guess. But the question came up, look, and this was from a school district superintendent, this report, this aggregated data represents a small data set. And I'm concerned that if you slice and dice it a particular way, you can identify individual students. And it was because the report drilled down into ethnic data. And I think it dealt with, if I remember correctly, the Pacific Islander class. Okay, and it so happened that there was only one student that fell within that ethnic category. So it's like, if I release this, everyone's going to know how this particular student did on this test. And our office upheld that denial. I don't know whether it made it to an appeal, but I think our advice ultimately was don't release the data. Based on the fact that we felt Furpa supported it. Don't release the report, deny the request. But it was an interesting case because this was not a standalone. We encountered it a couple other times as well. Now, here's an issue that is kind of interesting. Parents will file right to know requests for information about their kids or students that they're guardians for. And the school district will turn around and deny it based on the language in Furpa. But then the school district fails to notify the parent that, oh, by the way, the appropriate mechanism is to use Furpa itself, because that allows you then to see these records. So a right to know appeal gets filed, and we kind of slap the wrist of the school district. Why didn't you tell the parent? So if you're here from a school district, or if you're here concerned about a school district, you should be aware of this provision within FERPA and let the parents know. Okay, communication is good. You've heard me say that 100 times before. Okay, now, what if you have an emancipated student going to college and they get in trouble with the law and the campus police department? Well, those records are not protected under FERPA, okay? At that point, even though it's campus-related activity, that if they were in high school, it would be protected by the disciplinary policy, thus the disciplinary record, thus falling under FERPA. Once you get to college, it's no longer the case. And if the college campus police files a police report and other associated records, it's possible that those records are protected, but not under FERPA. FERPA no longer applies. What about school videos, Act 22, whether that applies or not, and how does FERPA come into play? Does FERPA protect students and their activities if they're caught on camera? And I wish I could give you a definitive answer here. This is an evolving area of right to know case law, and you're just going to have to take a look at how the courts have ruled on these individual cases. We've had some where the courts have said, yes, FERPA applies, you do not give out the videos. We've had others where the courts have said, given the circumstances, this was not a school-related activity, thus FERPA does not apply, you release the video. And then we've had some recent ones where the courts have said, you give out the video, but you fog out the students' faces. Okay. I think that kind of gives us a sense as to where the courts are headed, but we're not there yet to give you a definitive answer or definition on how you deal with these. I think it's a matter for your solicitors to take a look at, and ultimately it's just going to have to be sorted out by the courts. Okay, and then student health records, obviously FERPA protects those, but all those other laws that we were talking about earlier also come into play here. And then you have the Pennsylvania's Public School Code. It's the same as FERPA for the most part. It just kind of reinforces what FERPA has to say, taking it down to the state level. But one of the things that you should be aware of is that the Public School Code in Pennsylvania also gets into greater detail on health records. And a good example, you have a student, you have a school nurse, you have a student who is on medication and they have to take their medication every day at lunchtime. So the school nurse has records relating to that student and the issuance of medication. Those records clearly are confidential and protected by the Pennsylvania School Code. Okay, again, shifting gears, see what I did here? The Pennsylvania Motor Vehicle Code. All right, what about public employee license information? Well, that is protected by the Motor Vehicle Code, and I've had this come up. It applies to the Department of Transportation and any agency in possession of driver records. Okay, so how's this all work? Well, you go to the Motor Vehicle Code, section 6114, and it says a license is considered an individual driving record. Okay, it's a license is essentially a documented authorization to operate a vehicle, thus part of the record. Okay, and it's also referred to in the Right to Know law itself, section 708B6. Now, CDL, commercial driver's licenses, come into play here. And I had this, let me think of the context. Yeah, lady filed a Right to Know request. It ended up being denied. She was shopping around for answers, so she called our office and got me. And I explained to her how this comes into play. But the context of her request was, I saw so-and-so, this public employee, driving a particular piece of equipment, and I just don't think he's, authorized to drive that. And it was CDL covered piece of equipment. She filed a Right to Know request, and it was denied because CDL is part of a person's driving record, so they wouldn't release it. And yeah, Motor Vehicle Code, so I steered towards this language and said, they are correct in denying it, at least, but you're welcome to file an appeal. And ultimately she didn't bother, but I told her, this is my take on the Motor Vehicle Code, and this is how our office has ruled on this in the past. Okay, now, what if you have a public employee who has a problem recognizing the length of yellow lights, or maybe they have a lead foot and they end up in court? Well, those documents, those records, then are court records, which are accessible, any tickets or sanctions or the like, through the court system. Okay, and not necessarily through Right to Know, but you go to the courts and you can probably get those records then. Okay, here's an interesting one. I'm thinking, I haven't seen any appeals on copyright in a while. You know what? I think there was a recent copyright appeal, and I got some calls on this too, but let me talk about this. It's the federal copyright law of 1976. Okay, now this applies to anyone claiming or using intellectual property in the form of authorship. That's what copyright is, all right? And it's a federal law. Now, it protects records where the author is claiming original thought, such as an engineering or architect's plans or drawings. And this is where this comes up, and there's a lot of misunderstanding on these drawings. Now, most drawings that are used by government, you will find a stamp on there. And a lot of times, employees will misunderstand. They'll think, well, that's copyright. This makes it private. You need to take a closer look at that stamp, because usually it's a matter of an engineer or an architect simply putting their licensure stamp on there, saying, you know, I am a registered architect, or I am a registered engineer. You know, this stamp shows that I am qualified to prepare this drawing. That's all it does. Now, if there's a second stamp on it claiming copyright, then you take a closer look at how you manage that particular drawing or record or whatever. I'll come back to your question, Vicki, here in a moment. You know, typically the stamp is used, but under the Copyright Act, you don't have to use the stamp to claim copyright for original thought. Let me just go off script here a little bit. Occasionally, you will have an engineer claim original thought on a drawing, and it's simply because the municipality doesn't want everyone looking at what they intend to do for a particular subdivision or stormwater runoff project or whatever. There's not necessarily a valid reason. Now, most engineers follow what's called an industry standard. And there's no original thought related to an industry standard. You're either following the standard or you're not. If you are diverging from the industry standard and coming up with something new and unique, chances are the engineer and the solicitor have already pursued the legal ramifications of doing so. And I think it's very rare that they would deviate from an industry standard. I've never seen it happen, but I've seen engineers attempt to claim copyright for original thought when in fact they're following an industry standard. So that dog don't hunt, if you will. Now, architects, that can be a little different, because an architect can claim that their design is related to individual thought, or original thought, I should say. And they will typically have some better luck. And we've had some recent cases where this has come up, and I think we've supported the use of the copyright stamp. Okay, now what if you have that copyright stamp and it's valid in the way it's being used? Number one, the right to know, the Office of Open Records doesn't determine whether it's a valid use or not, okay? That is, the requester would need to file in federal court under the copyright law. But based on a court decision, Ali versus the Philadelphia Housing Finance Authority, what the court decision said is that a requester under the right to know law can inspect a copyrighted document, but they cannot have a copy. Okay, and if you're familiar with the right to know law, you have two options. You can inspect or you can request copies. And this one always sticks in my head because it goes back to the old axiom. If you want to know how a court is going to rule, ask George, and it's the exact opposite of what George tells you. And it's no difference here, because I listened to the verbal arguments on this. I listened to the court and the questions they were asking and some of the comments they were making, and I thought for sure they were going to rule a certain way, and then this is what they came out with. So if it's a valid copyright, the agency can allow the requester to inspect, but they cannot have copies. And let's say during inspection, they pull out a cell phone camera and take a picture. Don't get wigged out, because under the Federal Copyright Act, any dispute is between the person claiming copyright and the person allegedly misusing copyright. And simply taking a picture does not represent misuse. Okay. Okay, Vicky, let me come back here. Can I copy a driver's license to get permission to have alcohol on public? Okay, well, if the driver's license, yeah, I mean, you can make a copy. Let me make sure I understand here. You're requiring a copy of a driver's license so that you can give permission for someone to have alcohol in a public park. So you keep, and that, yeah. All right. Well, yeah, you can make a copy of the driver's license. It's just that if you get a right to know request for a copy that the agency has in its possession, you would not give it out based on that language in the motor vehicle code. Okay, I think that's an interesting point. I've never, Vicky, you get an extra donut this morning because I never had that question come up, but that makes perfect sense as to how that would work. You have to buy your own donut though. I don't have any here. Okay, then Margaret, are hearing transcripts copyrighted? No. Think about what is a copyright. Okay, you're claiming original thought. Well, a verbatim transcript of an adversarial hearing has no original thought. Okay, you're simply copying down the words that people spoke. Okay, so you couldn't claim copyright on something like that. Number one, someone would have to claim copyright. Number two, it would have to be bona fide original thought. Okay. I'm trying to think whether I cover, no, I don't cover transcripts in this. We do another webinar on payment issues and the right to know law, and I get into the whole issue of transcripts and right to know with that. So I would suggest, Margaret, if you haven't already, sit in on that webinar, which will be coming up in several weeks, and we'll talk about transcripts during that. Okay. Child Protective Services Law, while we're wrapping up here, this applies to anyone who in the course of their employment comes in contact with children. Okay, if you're in Pennsylvania, have child line clearances that needed to be filed because I help out with Bible school and that kind of stuff. So all those records, my application and so forth, are protected. But then we get into investigations. Okay, now let's put this in context of a government agency. It used to be when I was a kid, many years ago, our township, well, actually, I think it was our school, had a summer parks program. And, during the summer vacation, you could go over to the local elementary school and there were volunteers. Actually, I think it was school teachers who during the summer ran programs for us kids. All right. And nowadays, if something like that is going on, well, let's let's say that the volunteer sees bruises on a child and suspects child abuse. Legally, they're bound to report any suspicions, and that results in an investigation. Okay, and there could be, a medical evaluation, files kept on this investigation. All of that is confidential per the Child Protective Services Law. And the names of anyone involved in the investigation, including the volunteer who filed the report. Now, like I said, people initiating the report, that's kept confidential. I've had to deal with, this goes a couple of years back, but more than once, where you get into family dynamics where there might be a separation or divorce or something like that in play. And the parent, one of the parents who is under investigation for suspected child abuse files a right to know request. And the agency then is kind of caught in the middle of this investigation. Okay. Bear in mind, no matter how desperate the parent is because of what they're being accused of, and they're saying it's all a setup because we're going through a divorce, custody, child support, and all that. No matter how compelling a case they make, for wanting to know who filed the complaint, the agency cannot release that information. Okay, they simply legally cannot. Please keep that in mind. Okay, and then again, going back to these child abuse history clearances through Childline, like I was describing initially, all of that application information is also protected by the Child Protective Services Law. Then we get into potential elder abuse, the Older Adults Protective Services Act. This applies only to those agencies, agencies, not the public in general, employees or administrators who suspect elder abuse. And it would protect all reports of abuse or neglect, investigatory materials for people 60 years or older who cannot protect themselves and are at risk of abuse or neglect. Okay. This one is very rare, but interestingly, just last year, it came up with the Pennsylvania Department of Aging, and we had to take a look at it. I was ready to actually remove this from the presentation, and then it came up again. So it's rare, but it's out there. If you work in a facility that deals with older adults, you're probably already aware of your obligations to report any suspected elder abuse. And all those records, again, are considered confidential. Okay. Disease Prevention and Control Act of 1955. This came up with COVID. And it was used by the Pennsylvania Department of Health to withhold COVID-related aggregate data. I think this has pretty much run its course where the courts have said this does not apply to aggregate data, only individual data, but it's still out there. And whether or not the legislature updated it or not, I don't know. I need to check on that. I know there was a lot of talk of them updating this act, but I don't know whether it ever made it out of committee. But it does allow the release of aggregated data. And what's interesting is that I'm traveling this weekend out of state, and I just got an email this morning from the hotel saying that I have to take a mask, which, wow, I didn't know that. But so I haven't encountered that in years either, but it's out there. So, and I guess the point is, this is not necessarily going away. So, we could still encounter the Department of Health or a local health board claiming this act to withhold information. I think the courts have pretty much provided the clarity that we need, but, like I said, it's not going away. We could see it all come up again. All right, and then some miscellaneous issues that we should be aware of. W-2s under the Internal Revenue Code are confidential. It still amazes me that people want to see tax information. I think what it comes down to is they want to see salary information for a public employee, so they file a right to know request for the W-2s. Okay. Now, salary information is clearly public. W-2s, though, are not. So it's a matter of, it's probably best that the agency circle back to the requester and say, look, we can't give you the W-2, but is it because you want the salary information? We'll provide you with that. Okay, that saves everybody a lot of trouble there. But W-2s in and of themselves, confidential per the IRS. Then in Pennsylvania, we have the Taxpayer Bill of Rights, which makes it a misdemeanor to release any confidential tax information for whether it be a public employee or anybody for that matter. You simply don't give that stuff out. Same way with LT, otherwise known as the Local Tax Enabling Act. if there's any sort of tax investigation by a local tax bureau, or let's say that a municipality still is collecting taxes on its own, and there's any sort of investigation taking place, that information is protected. It's considered confidential under LT. And then finally, home addresses and dates of birth. This goes back quite a few years to Campbell versus Pennsylvania State Education Association, where Mr. Campbell filed a right to know request for the home addresses of public school employees. Okay, worked its way all the way up to the Pennsylvania Supreme Court. The Supreme Court said yes, home addresses for public school employees are confidential. And we are saying this based on the Pennsylvania Constitution and the right to privacy that we interpret being within the language of that document. Since then, it has been expanded by both the courts and our office to include home addresses for just about anybody. There is a thing called a balancing test where you weigh the public's need to know versus the individual right to privacy. We have ruled on both sides of the scales as to whether an address should be released or not. But essentially, the starting point is that address is considered private unless there is an overwhelming public concern for the release of that address. Same way with dates of birth. This is germane given all the concerns with identity theft. You would not release the actual day, the date. But where we're at now with the courts is that the month and the year can be released, but not the actual day. All right. And if you go to my Facebook account, yeah, you can find out when the actual day is. But for purposes of right to know and government agencies, you would not give out the date of my birth. That's considered protected information under the constitutional right to privacy. Okay, we are at the end of the presentation. Thank you for your patience in dealing with, I don't know why, of all the things, I'm surprised it was PowerPoint that crashed, given that we were dealing with teams and operating systems and all kinds of things otherwise here today. But thank you for your patience. Thanks for helping me out getting set up here. If there are any other questions before we end the presentation, now's the time to get them in. If you're new here today, I want to point you towards our website, openrecords.pa.gov. It is the best government website you will ever encounter. It is updated 6 days a week with new decisions, training opportunities, court rulings, anything related to government transparency we put out there on our website. There are guides for citizens, guides for agencies. If you happen to be an agency open records officer, we have a guidebook on there, 78 pages, which you can download for free. That has all kinds of useful information with you setting up your open records program. Like I said, training opportunities. If you are a real geek about government transparency, subscribe to our X account, and we will wake you up every morning at 7 a.m. with all the news that's fit for the day about government transparency. And then finally, if you have a problem, if you have any questions, reach out to our office, send us an email, or dial the number on the screen, and we will help you out, okay? Looks like there's no more questions, so I'm going to end the presentation. We'll be back in 2 weeks. And again, thank you all for your participation today. Take care.